Obligations and contracts are everywhere, whether you're buying a house, taking out a loan, or making a business agreement. But what exactly makes a contract legally enforceable? In this video, we're breaking down obligations and contracts as covered in Chapter 11 of the 2025 Fundamentals of Louisiana Notarial Law and Practice. At its core, and according to Article 1756 of the Louisiana Civil Code, an obligation is a legal relationship in which one party, known as the obligor, is bound to perform or refrain from performing a certain act in favor of another party called the obligee. This performance can involve giving something, doing something, or abstaining from doing something. An obligation is a legal duty that can arise in several ways. Some obligations are voluntarily assumed, such as those found in contracts, while others are imposed by law, even without an agreement between the parties. Article 1757 of the Louisiana Civil Code explains the different sources of obligations in which they can arise by any of the following. 1. Contracts. Contracts are the most common source. These create legally binding agreements that voluntarily establish obligations between parties. 2. Declarations of will. A person may create an obligation through their stated intentions in a declaration on a will, such as in a testamentary bequest. And 3. Operation of law. Some obligations are a result of operation of law. These can exist without any agreement between the parties. This includes wrongful acts. For example, when someone causes harm, they may be obligated to compensate the injured party, similar to tort law in common law systems. Management of another's affairs. For example, if a person acts on behalf of another without a formal agreement, the law may impose obligations to ensure fairness. Unjust enrichment. For example, if one party benefits unfairly at another's expense, they may be obligated to restore what was gained. And other acts or facts. For example, certain legal responsibilities arise due to unique circumstances dictated by law. This broad scope of obligations ensures that legal responsibilities are not just based on contracts but also on fairness and justice in social and economic relationships. Types of obligations. Obligations can take different forms based on how they are structured. The types we will briefly cover here are not mutually exclusive, and the content within this chapter does not exclusively define every type of obligation. First are real obligations. These are tied to property rather than a specific person. Second are personal obligations. These are tied to individuals based on agreements or duties. Third are conditional obligations. These are obligations that only take effect if a certain event happens, like a sale contingent on financing approval. Fourth are solidary obligations. This is when multiple obligors are each fully responsible for fulfilling the obligation, as in co-signing a loan. And fifth is divisible versus indivisible obligations, in which some obligations can be split, divisible, while others must be fulfilled entirely by one party. Contracts, the backbone of legal agreements. Contracts are a specific type of obligation that create legally binding agreements between parties. Civil Code Article 1906 defines a contract as an agreement by two or more parties whereby obligations are created, modified, or extinguished. Additionally, contracts can be drawn up for mostly anything subject to the legalities of Civil Code Article 1971, which states the following. Parties are free to contract for any object that is lawful, possible, and determined or determinable. This means a contract is possible as long as the proposed agreement is not illegal, nor does it have any detrimental effect on the public, or violate a public policy of the state. For example, a contract to perform an illegal act would be null and void. However, for a contract to be valid, it must meet key requirements. Those requirements are as follows. First is consent. All parties must willingly agree. Second is capacity. Each party must be legally able to contract. Third is object. The contract must have a lawful purpose. And fourth is cause. This means there must be a legal reason for the obligation. Once a contract is formed, it must be performed according to its terms. If a party fails to uphold their obligation, it leads to a breach of contract, which can result in damages such as financial compensation for losses. Specific performance, in which there is a court order requiring the party to fulfill the obligation. Or dissolution, which involves termination of the contract if performance is impossible. Understanding obligations and contracts is essential for Louisiana notaries. These legal principles form the foundation of business transactions, real estate deals, and everyday agreements. If you found this helpful, subscribe and hit that notification bell so you don't miss more notary exam prep videos. Have questions? Drop them below and I'll be happy to answer them. Thanks for watching, and we'll see you in the next video.